And let me share the presentation. All right, so let me move this. All right, team. Good afternoon. How are you?
Good afternoon.
Awesome. Thank you very much, guys. All right, so part of the process in understanding your role as a real estate professional is the rules and regulations that not just the MLS, but also the California Association of Realtors, which is the Code of Ethics, and the importance of your position if you're representing the buyer or representing the seller, and the stipulation of what transpires when you are submitting an offer. Now, we're going to go through some of the elements of the Code of Ethics and also some of the elements of the multiple listing service, right? That way you get a better understanding how to navigate these offers. Because I always get this quite often is, you know, if there's already an offer in place or multiple offers in place, does that mean that we're out of luck? We cannot submit an offer? So we're going to go through those elements and understanding that if a buyer still requests you to submit an offer, even though it's pending, you still got to submit an offer. If you're the listing agent representing the seller and you're in escrow and an offer comes in, even though it's pending, guess what? The listing agent still needs to present that offer, even though it's in escrow, even though you're about to close. Those are some of the motions and approaches that I want you to understand. So let's dive in deep on the rules regarding presenting of offers. Okay, that's not working. All right, so let's talk about the NAR, which stands for the National Association of Realtors Code of Ethics, Article 1. The Code of Ethics and Standard of Practice of the National Association of Realtors was in effect on January 1st of 2018. And it says the following: when representing a buyer, seller, landlord, tenant, or any client as an agent, realtor pledges themselves to protect and promote interests of their clients. Okay. Have you ever heard the phrase, you know, you want to take care of your client's best interest? Well, that's what it's defining. All right. We are held to a higher standard, but more so, we have to protect our client's best interests. Now, how do you do that when you represent both the buyer and the seller on a dual agency, right? That can be a little difficult and sometimes a little challenging because you know pertinent information of the seller as much as you know information of the buyer. And how do you keep that defined line where you don't cross over? Because as soon as the buyer and the seller says, well, Simon, you did not take care of my best interest, guess what? You may not be entitled to a commission. So the pros and cons of understanding your approach, but then they can also, if they do a little bit of research, which this is all public information, they can say you broke one of the core Code of Ethics, which is Article 1. Okay, and Article 1 says that you are there to protect your client's best interests. Just that in itself, if they can articulate that, guess what? They win, you lose, you're out. Meaning you may lose the listing, you may lose that buyer, and unfortunately, you may also potentially lose your commission. Sucks. But the reality is, this is why we have standards in place. This is the reason you're called a realtor, not a real estate agent, because you held yourself to a higher standard and pledged to be a member of a association and part of the national and also the California Association of Realtors. Make sense? The obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly when serving a buyer, seller, landlord, tenant, or any party in a non-agency capacity. Realtors remain obligated to treat all parties fairly and honestly. Okay. Okay, standard practice 1 through 6 says realtors shall submit offers and counter offers as quickly as possible. So what does that mean? You know, shall or obligation, right, as quickly as possible. What does that mean in your opinion? Anyone?
Basically right away.
Okay, yeah. Immediately, right? It says as quickly, as efficiently as possible. So if you are working with a buyer, right? And the buyer says, hey, I'm interested in this property. I would like to submit an offer. Now, under the rules and regulations, the only aspect of that you are obligated is if you have a relationship with them, what we call the agency relationship, right? It's the AD form, right? Which entitles you to work with a buyer, to work with a seller, to work with an investor, or even possibly a developer. With that, that gives you solid ground and understanding that once you have any conversations regarding real estate talk, you always want to provide this agency disclosure because it defines buyer's duty and responsibility, seller's duties and responsibility, agents' duties and responsibility as well. Okay. Without that agency disclosure, and I'll show you a copy of what the agency disclosure looks like, very important in any conversation you're having when it comes to real estate conversations. Okay. If you're ever in a litigation, arbitration, or lawsuit, and you're fighting for a commission, the first thing any attorney, any judge, any arbitrator, or even a mediation person is going to ask, do you have a signed agreement stipulates that you have a relationship with this buyer or with the seller? And if you don't, then unfortunately, that's one check off you that unfortunately, whatever the case may be, if you're fighting for a commission, fighting for a listing, or fighting to defend yourself with a relationship that you work with, that may be tossed out. So it's very important that you have that agency in place. But it says you submit all offers, right? Submitting offers. If the buyer says, you know, Simon, please submit an offer on this property here on 123 ABC, you want to do it as quickly as possible. Okay. That doesn't mean 3 weeks from today, 2 days from today, right? It means as soon as practical, right? Now, if you're in bed, you're asleep, and you get an email or even a text, obviously, you know, that's different, right? But if you're having dialogue and conversation with someone, you want to make sure that not a problem. You know, I am, you know, facilitating other stuff, but as soon as I'm able to jump on the computer, draft the agreement, I have all your documentations, I'll send it to you via DocuSign, or you can come and meet with me here in person so we can actually get the wet signature, and then I can send it out to the listing agent for at least acceptance or acknowledgement. Make sense? Okay, so shall submit as quickly as possible. And this is why I highlighted this, because these are crucial components to your standard practice. Now let's talk about standard practice 1 through 7. It says, when acting as a listing broker, shall continue to submit to the seller, the landlord, all offers and counter offers until closing or execution of a lease, unless the seller, landlord, has waived this obligation in writing. Meaning, you're the listing agent. Now we're flipping the hat. You represent the seller. You service the seller. You got the property in escrow. Congratulations. It's a 30-day escrow. You're 15 days in already, right? Buyer has done their due diligence on the property, are doing inspections. They're going through the negotiations of request of repairs, right? Buyer's going through the trenches of getting the appraisal done. So that way we know where they stand with the evaluation, right? You're the listing agent on this aspect. What standard 7 says is that regardless of where you're at with the seller, any and all offers that come in, you must acknowledge. And if once you acknowledge, you need to present those to the seller, where you're saying, well, Simon, it doesn't make any sense. How am I going to present us an offer if we're already in escrow, right? Well, under standard practice 1 through 7 of the Code of Ethics, it says that any offers that come in, you shall submit to the seller. It's the seller's discretion, not the agent's discretion. It says, because I have authority, I'm the listing agent, I say and dictate what I want to do. No. It's the principals involved in this transaction. It's the buyer or the seller that have the say so. And if you get specific answers or instructions, I should say, then you must follow those instructions. Obviously, you're not going to do anything fraudulent. You're not going to do anything that's crooked or take any shortcuts, right? Because then that's a whole different element that can cause you issues with your real estate license, right? You don't want the Department of Real Estate on your back, especially if you did something that you shouldn't have done. I'm going to leave it as that. Okay. Make sense? Any thoughts, questions about that? It's pretty self-explanatory, right?
I remember on the exam, there was like, I saw two contradictory answers when it said like, if you get specific instructions, that the buyer doesn't want to receive, the seller doesn't want to receive any more offers.
Yeah.
Are you still supposed to present it to them because that's what they said?
Yeah. That's a very valid point. So the answer is yes. If they give you written instructions, okay, so here it is. The seller has waived this obligation in writing. Okay, then the realtor shall not be obligated to continue to market the property after any offers have been accepted by the seller. So only after the seller says to you, all right, Simon, any and all offers that come in, don't even waste my time, don't even submit them. But if I get an offer that is 100,000 more than what we're at in escrow, then by all means, that I will definitely entertain. Meaning you cannot unilaterally cancel an escrow because you got a higher offer. But what you can is hold that one and see what the buyer is willing to do. If the buyer is still in it for the long haul and close, or if the buyer eventually will back out and cancel, then we can get the new buyer into escrow.
But when you're in escrow though, you can't just like be like, oh, never mind, this seller is, or this buyer is better offer. You can't just
No. So once you're in escrow, it's like a relationship, right? Once you're in escrow, you're in that relationship, then you got to finish it to the end, or either party has to mutually agree on a cancellation, either because they breached the contract or the buyer has the right within its contingency period to back out of the deal. Okay, so there's pros and cons to this, guys and ladies, is the ability to understand your role and your position. This is why it's crucial that you know every aspect of the process. Okay, and this is one of many different variables that we can approach it and see it from two different perspectives. You may see it different, you may see it different, I may see it different, but the angle is always going to be the same, and the end goal is obviously to close the deal. Okay, but with that being said, the buyer and the seller have to agree to these terms and continue moving forward to the finish line. And then until there's an agreement and meeting of the mind, then it continues. But if there isn't, then there's a halt and a stop, and then we have to either stop and renegotiate or find what's the best avenue for both, or decide to break that relationship and both mutually cancel. Because the contract and the process says this, that it has to be mutually agreed of cancellation. Just because the buyer wants to cancel doesn't mean that the seller agrees to the cancellation, or vice versa. Okay, it has to be mutually agreed. And if there is a breach in contract, meaning that the buyer has released any and all contingencies, right? And now the buyer wants to back out, which the buyer can, but that also gives the seller the right to go after the deposit. This is the reason, we have these type of transactions. And this is the reason, in order for the buyer to get the property in escrow, hold and tie up that property for 30, 45 days, the buyer also has to have a little skin in the game. Okay, this is why you have monetary deposits in there to protect the seller if the buyer decides to back out at the last minute, right, and says, you know what, I changed my mind. Well, now it exposes the buyer's deposit and there's damages that incur. with that also, there's what we call layers of wall. Okay, this is the earnest deposit, right, of $20,000. Okay, let me go here. Maybe they can see me better. Okay, $20,000, right? This is the $20,000 that the buyer put in to hold that property in escrow for 30 days. Now, contingencies are walls. These are the walls that safeguard that deposit, right? Every time a buyer releases a contingency, then the seller is getting closer and closer and closer to that deposit. Once the buyer releases any and all contingencies, now it's exposing the buyer's deposit. If the buyer decides to cancel, the seller may have rights to that deposit. Okay. If the walls are still there protecting that deposit and the buyer decides to cancel, well, unfortunately, the seller has walls that unfortunately it's going to take a challenge to be able to go after that deposit. But if the buyer is within their rights, right, within the rights to cancel during their due diligence period, meaning physical inspections, appraisals, disclosures, or loan, these are the walls we consider, then the buyer can back out, no questions asked, and the money should be returned back to the buyer. Okay, so those are the avenues and how you navigate this. Question.
What is the seller's option if something like the previous example we were talking about, like they're in escrow, an offer comes in for substantially more, what can they do?
The seller cannot really do much into the buyer's position if the buyer is going to continue. Now, the seller can put a little pressure on the buyer to perform. Okay, this is why you want to make sure that if you're representing a seller, right, when you're sending a counter offer is submitted, offer is reviewed, seller will typically counter some terms or conditions. And it may be that the buyer is asking for 30 days, but the seller needs to vacate and move out. The seller may say, I'm not going to give you 30 days, but I'll give you 20 days to close this deal. And the buyer agrees to close in 20 days. And now 20 days, now you're in escrow and the buyer has not performed, then that gives the seller the right to send up what's called a demand to close. That gives the buyer 72 hours to close. And if the buyer does not close, then the seller has the right to cancel, possibly retain some or all of the deposit, put the property back on the market, and find a new buyer. Now, to answer your question, if you're in escrow, you represent the seller, right? And the seller gets another offer that's 50 or 100,000 more than what you're in escrow, seller is going to say, well, heck, let's cancel with this, open up escrow. Well, there's pros and cons to that. And what I mean by that is very simple. There's no guarantee, right? No guarantee that this buyer that submitted a higher offer is going to be able to perform. We don't know all the aspects and every element of the buyer yet. And if the seller goes in that direction, there's still no guarantee that the second buyer will not perform and close. So it's a gamble. Now, with that, it's not that easy for the seller to say, cancel on this one, let's open escrow with another one. Because imagine this, right? You're the listing agent and you represent the seller, you're in escrow and someone offers 50,000. Then another offer comes in for 100,000. Then another offer comes in for 150,000, which is ridiculous, right? You're not going to be canceling because you want the highest, right? This is why you got to educate the sellers. And this is why we have the standard of practice to understand our role, our position. These are what we call rules and regulations, right? We all have them. It doesn't matter what type of line of work you do. If it's, working in a warehouse, retail, there's rules and regulations and policies and procedures, right? Well, it's the same with us as well. There's rules and regulations and standard of practice of what we do and what we should be doing and what we should not be doing. Does that make sense? Okay. So going again back to your question, the only way that the seller might be able to is if the buyer decides to cancel, backs out of the deal, or the seller within its right forces the buyer to either perform and the buyer does not perform, then the seller has the right to cancel, execute out of that, and then ask and start negotiations with the new buyer and then open escrow. And I've seen even situations where the buyer has breached the contract and the seller has canceled on the buyer, but the buyer hasn't mutually agreed to cancel. The seller, within its right, still may be able to go and open escrow with the second escrow and work with closing on the second, even though there's still an active pending escrow with the existing. Now, be careful, okay? Those scenarios, situation, you must bring me to the table, okay? Say, Simon, I got a very unique situation. I need your opinion as the broker. You know, I'll come in there, I'll step in, navigate, have those conversations, go on a three-way call, or even go in person if it's local. I mean, how many times have I been in mutual dissolutions of diffusing a situation where I'm proactively engaged in a conversation in person with sellers, investors, or even agents as well, okay? It's like I'll roll up my sleeves and whatever it takes to help you either close that deal or ultimately cancel so you can move on to the next buyer, okay? Again, there's pros and cons, but when something starts going left field, right? Or something starts going right field, you know, and it's not in its lane, bring me to that attention so I can help navigate those conversations. And if we have to, we can also bring the attorneys involved as well, and they can also help with legal advice. Okay, I know that was a lot of information, but I hope that kind of gives you a perspective and a gauge on what I'm trying to explain. I mean, we can go hours and hours and hours on different scenarios, different views, different opinions. Nothing is right, nothing is wrong. It just kind of depends on how it plays out. Because I've seen some crazy stuff that violate the standard of practice and it still goes one different way. It's like, wait a minute. The agent or the buyer, the seller were in the wrong, but I've seen it go this way. Okay. So that's why for me is nothing is really black and white in real estate. And real estate, even though it defines, and you should understand, you know, common practice of contracts, which you should understand and get familiar with the purchase agreement, the listing agreements, the disclosures, because there you can arm yourself in a position just like an attorney preparing to go to court. Okay. The more you know, the more knowledgeable you are, the better prepared you're going to be to really navigate that approach to help your client or even yourself through the trenches of a deal. Does that make sense? Okay. So going back, that if the seller or the buyer gives you written instructions, here the seller waiving the obligation in writing, then yeah, you don't have to receive any additional offers. You can kindly tell the agent saying, you know, unfortunately, we are not accepting any offers. Do not bother sending. Even if you send me an offer, it's not going to be acknowledged. And you have the right to say that as long as you have something that backs you up from the seller saying, well, the seller has in writing told me that any offers that are not, you know, in excess of this, they're not going to even consider. Because what it says under standard practice 1 through 7 of the Code of Ethics, it says that any and all shall be submitted to the seller. So even if it's $1 offer, which is ridiculous, right? But if an offer comes in for $1, you got to present that to the seller. Does that make sense? Okay. Any questions?
Well, it doesn't really make sense, but but yes, I understand.
The logic to that, the logic to it. So yeah, no, it's good stuff. It's really good stuff. But yeah, I've seen some, and I can share so many war stories on things that I've seen here in the office. It's like, wow, man, that's crazy. And then you can also go on the California Association of Realtors website, and you will see all kinds of mock real life scenarios. And it's like, you kind of scratch your head, like, really, this agent did that? And this is why they violate some of the standard practice. And then they get their photos like a mugshot, and it has a little bit of information of that agent, what rule they broke, and then a scenario summary of what got them in trouble. Yeah, it's pretty gnarly. It's pretty crazy. All right, so let's continue. Shall not be obligated to continue to market the property after an offer has been accepted by the seller. Realtor shall recommend that the seller obtain advice of legal counsel prior to accepting any offer. So obviously, yes, the pros and cons, and yeah, bring it to the broker's attention, but also remember that if you're an escrow, then you're basically embedded in that transaction. You either close it or you cancel, then you move on. But common sense and common rules of these standards is any offers that come in, you still need to present to the seller, even if it's less than what the offer you're in escrow in, okay, until you got that in writing. All right, so let's talk about the MLS rules. So you have CAR, which is the California Association of Realtors. Then you also have the multiple listing service, better known as the MLS rules. Now, the policy and procedures is probably 280 pages. And yeah, you can go through it. It's boring as heck, but there's certain things that you should understand. The rules of the multiple listing service and the rules to the Code of Ethics, which is the National Association of Realtors, and also the California Association of Realtors. So California Model Multiple Listing Service rules suggest rules and regulations for an MLS operated as a committee of a local association of realtors in California, which was amended in February of 2018, prepared by the California Association of Realtors. So there's a lot of people in the cookie jar, okay? Now, there's pros and there's cons to all that we do. Remember, at the end of the day, it's always using common sense, okay? All of us know what common sense means, right? If it doesn't resonate well, then it's probably something you shouldn't be doing. If you think that taking shortcuts in real estate is the best approach because you want that finish line and collect a commission, then guess what? Eventually that feeling is going to get to you. This is why you can survive real estate, but you can also die in real estate. Not in that way, but I'm saying you can basically lose the opportunity to continue, doing real estate. And a lot of people get in trouble. As I said, I was actually talking at the team meeting for the Long Beach office. I was telling, the importance of always do the right thing, never take shortcuts. But the Department of Real Estate is not our friend, okay? Yes, they give us a real estate license, but as fast as they give you a license, it's as fast as they can revoke, suspend, and terminate your real estate license as well, okay? So you've got to understand those elements too. It's no difference in driving privileges, right? You always want to drive, but the minute that you reckless or DUI or whatever, they can pull that license from you, right? And it's very expensive. So the models that we have are, the National Association of Realtors, the California Association of Realtors, and our local boards, but more so the multiple listing service. And, in the state of California, we have numerous of boards, right? CRMLS is one of them, which is most of the Southern California agents that utilize it. You go to the west side, you have CLAW, which is the MLS. They have a different platform, but the rules and regulations are pretty similar, okay? They may have some tweaks here and there, but everyone kind of has that same standard. Now, the California Association of Realtors has standards across any board in the state of California. Everyone must follow those rules and regulations. Any questions? Okay, Model MLS Rule 9.9 says the following: submission of offers and counteroffers. What are you obligated is the question here. The listing broker shall submit to the seller, landlord, all offers until close unless precluded by the law, governmental rule, or expressly instructed by the seller. Otherwise, cooperating broker acting for buyer shall submit to the buyer shall submit to buyer tenant all offers and counter offers until acceptance. So basically is what they're stipulating here is any offers that you receive as a listing agent, you must entertain, pass those on to the seller and let the seller decide what they want to do. Now, under the rules and regulations, remember, you have a duty to instruct, guide, and ultimately make sure that you're taking care of their best interest, right? Making sure that they're not going to be in a liability scenario, right? Because that can happen. If you give bad advice and they get themselves in the trenches of something, guess what? Who are they going to be pointing fingers at? Simon, right? Me. It's like, you told me, Simon, to do that, and now I'm in this deep hole. So be very, very careful in how you navigate this. Now, what Rule 9.5 says that any offers that your clients ask you to submit, you're going to submit. Okay. Well, Simon, or John, if this property is an escrow, I understand it's an escrow, but I want this as at least that the seller has acknowledgement, because we don't know if this buyer is going to perform and close. And I've seen scenarios where it's active, goes into pending, and you kind of forget about it, and all of a sudden it pops up 3-4 weeks later. It's like, damn, it's back on the market. We should have submitted an offer. Now you have multiple offers where you can, submit an offer even though it's pending. Call the listing agent and say, hey, this is Simon with Keller Williams. My client has instructed me to submit an offer. I know you're in escrow, but I wanted to be proactive just in case your escrow falls out. We want to be in position, one, to be able to go in. A buyer's solid. He's been pre-approved. They're putting 25% down. We can close in 20 days. We'll narrow our contingency period. We're ready to rock and roll. Their credit is good. Their income is solid. Their FICO scores are golden. We're good. My client has instructed me to submit an offer because they're hoping that it falls out and we can go into first position. Does that make sense? Okay, so that's the reason you do that. Now, going on the flip side, the listing agent says, no. We ain't accepting any offers. Well, tell me more about that. Because the rules and regulations says you must still present to the seller. Now you can go back to the standard rules of 1.7 and says, due to the standard of the code of ethics, you shall, present the offer, regardless if you're an escrow. I understand that, but I want to make sure that our offer is acknowledged. Because if this deal cancels, I want to be able to move in and go into escrow. Okay.
Why they wouldn't want to have a backup plan.
100%. 100%. Absolutely. So that's why you do what you do. Now, if the listing agent says, look, Simon, I appreciate the offer, but right now, the seller is not entertaining any offers. I have written instructions that says otherwise, and you have to apply that. No problem. I will relay that information to the buyer and says that we're not going to be able to submit an offer. Okay, as long as you're following those guidelines, you're golden. Okay, model rule 9.4, presentation of offers. The listing broker must make arrangements to present the offer as soon as possible, or give the cooperating broker a satisfaction reason for not doing so. In the event a listing broker will not be participating in the presentation of the offer, the listing broker shall clearly indicate the fact in the listing information published by the service. Okay, so here's one of the things that you can do, okay, to protect yourself, is on the MLS. Once the MLS, because you have the authority, right? You have the obligation, and it's your responsibility. Put it on the MLS. Okay, and when you put it on the MLS, there's a section where it says agent remarks. That's where you, as the listing agent, can say, seller is waiving any offers to be presenting during the pending transaction, right? It's already pending, but you can also put in writing that the seller has given us written instructions not to submit any offers. Now, I haven't seen that, and I've been in this industry for a long time. I haven't seen any remarks that says otherwise. All I'm saying here is you have that ability to submit offers, but also you can have that disclaimer on the MLS says seller has given me instructions not to submit any offers. Or you can even say submit offers that are over 100,000, 200,000 above what we have, then by all means, submit your offers. But there's nothing that the buyer can do or the buyer's agent that's in escrow, because the buyer's agent can say, well, wait a minute, we're in escrow. Why are you promoting this? You know, why are you trying to fish for other? We're in escrow. I get it. I understand. It's now you're on that fine line, walking on that rope, right? Making sure that this buyer performs, the buyer gets the loan, buyer gets the appraisal, buyer reviews the disclosure, and the buyer gets all the requests of repairs in line. And if not, we're going to cancel on you and at least have an opportunity to open with someone that's going to be efficient and fast. Okay, that's why we do what we do. And the more you practice, the more you're engaged, the more you understand, the more deals you do, you'll get it. You'll understand. Okay, so that's what it says about 9.4. We're almost done, guys. Hang in there. All right, MLS model rule 9.6 says right of cooperating broker in presentation of offer. And I've highlighted this. The cooperating broker has the right to participate in the presentation of any offer to purchase, and that's a typo, I think, his or sources. The cooperating broker does not have the right to be present at any discussion or evaluation of that offer by the seller or the listing broker. However, the seller gives written instructions to the listing broker requesting that the cooperating broker, meaning the buyer's agent, not to be present when an offer the cooperating broker secures is presented. The cooperating broker shall convey the offer to the listing broker for presentation. In such event, the cooperating broker shall have the right to receive a copy of the seller's written instructions from the listing broker. Nothing in this section diminishes or restricts the listing broker's right to control an establishment of appointments for offers presentation. That was a lot of information, right? It's like, wait a minute, what does all this mean, Simon? What the heck are you talking about? Okay, what it means basically under the rules of 9.6, right of cooperating broker to present offer, meaning that I'm going to go back in time. I'm going to jump on that DeLorean, right? Remember that DeLorean from Back to the Future? Jump on that DeLorean, pushing numbers and say, I want to go back to 1995, December, whatever, right? Plug in those numbers. Now you're going 80 miles and eventually the kilowatts, right? Takes you back in time, right? Well, back in that time, if you were a real estate agent, we didn't have the technology that we have now. Back in that era, that was my era when I started real estate, we used to present offers all the time. We would call the listing agent. Hello, my name is Simon with Keller Williams. My clients preview your home on 123 ABC Street and would like to present an offer to the sellers. Could we present today at 7 o'clock? We're willing to present at the seller's home. And the listing agent says, yeah, well, 7 o'clock will not work, but 6 o'clock, not a problem. Let me coordinate with the buyer to see if we can meet up at 6 o'clock, right? And confirm. We confirm and we're solid at 6 o'clock. Guess what I was doing? Driving to the listing, not my listing, but the listing agent's listing that my client wants to submit an offer. I drive there, knock at the door. At 6 o'clock, I'm here for my appointment, presenting my offer. Then we would introduce myself. Hi, I'm Simon with Keller Williams. Usually I had the listing agent there, and then we would also meet the seller. Whoa, deep, right? It's not like we do now. We submit an email, we text and all that stuff. No, we used to physically present these offers to the sellers. Imagine that. Your skill set, your ability, right? It's like an interview, right? With uncertainty that you're going to get your offer considered or accepted or rejected. That's the traditional way that we used to do real estate. Present the offer, which stipulates that 9.6, that the agent has the right to present the offer. Well, a lot of agents now that have got into real estate in the last 20 years don't understand this practice. Old school guys with gray hair like me do know that we can, to this day, present an offer. How cool is that? But how stressful is that as well, right? Think about that for a minute. Imagine that you get a response back from the listing agent says, hey, you know what? I don't want you to email me. I don't want you to text me the offer. Come and present it to me and present it to my seller. Whoa. You don't hear that anymore, right? But imagine if a listing agent like myself says that to put you in that position, right? It's not a bad thing or a good thing. It's just that's the way I roll. Well, under this paragraph, it allows the buyer's agent to present the offer. Now, it says on the contrary, that if the listing, or excuse me, that the seller gives you, again, what? Written instructions, that the listing broker requesting that the cooperating broker not to present. Okay. Then you can decline the buyer's agent from presenting the offer to the agent or to the seller. That's what it says. That's simple. So what if this wasn't part of the equation, right? Not part of the equation, but now the listing agent says, shoot, I don't have anything in writing. I better call the seller, which the seller can. The listing agent can, say, hey, ring, this is Simon. Hey, by the way, I got an agent out of Keller Williams. These Keller Williams agents are just aggressive. They don't want to just email me the offer or text me the offer. They want to present it to you in person. How dare these Keller Williams agents, right? And the seller says, well, that's kind of weird, or that's kind of strange. It's not strange if you understand the rules and regulations, but the seller may feel uncomfortable, and that's perfectly fine. And the seller may tell me, Simon, hey, I don't feel comfortable with the agent presenting an offer in front of me. That's why I hired you. This is why you are my realtor. Handle it. No problem. Put something in writing for me, saying that you're instructing me that no offers to be presented to you. And then that's my defense. I'm going to let the buyer's agent, unfortunately, seller will not be accepting any present offers. So please email me. And then I could show written confirmation from the seller. Does that make sense? Any questions? It's pretty self-explanatory, right?
Sure.
Yeah.
I have a question. What about presenting offers to the seller, like just the seller's agent presenting offers to the seller in person versus over the phone, or what is the recommendation?
Meaning the listing agent who represents a seller
Yeah.
picks up a buyer who wants to submit an offer, and now the listing agent is submitting an offer.
No, I mean like the offer is presented to the listing agent. Okay. And then the listing agent then presenting it to the seller. Doing that in person, because you have to do it as soon as possible.
Correct.
So doing that in person versus like over the phone or something like that.
Yeah.
Is there a preferred recommended way of doing that?
Well, it really depends on your client's discretion. Most of the time, and I mean, when I say most of the time you are going to be in front of your clients. I've done that many times. Many agents still, meet up with the sellers. Hey, I'd like to schedule. We have 3 offers that came in. I want to sit with you, Mr. and Mrs. Seller, to go over all the offers and a summary of what offer A, offer B, and offer C. Could today at 5 o'clock work or 7 o'clock work best, or we can always do it for tomorrow. So the answer is yeah, you can in person. Oh, absolutely.
Not even like can you, but like, is that
It's-
recommended more so?
Oh, yeah, absolutely. Remember, you still got a lot of older generation homeowners that like that, face-to-face interaction, especially with you as the listing agent, right? They hired you when you went on the listing appointment, you met with them. You gave them your marketing strategy, you gave them, your comparable market analysis, you told them, my opinion and value, you're going to meet with them. So yeah, absolutely. It's still common practice to present the offers in person with the seller. Yeah. Make sense?
Yeah. So I'm just viewing like the wording as soon as practicable or whatever the wording was.
Well, that soon as possible can mean, as soon as practical to you and practical to the seller. Because it cannot be practical if your clients are in Colorado, right? Up there skiing right now, they're not gonna be back till Sunday. You're not gonna go to Colorado, right? But what as soon as practical is, I'm gonna submit the offer via email. You should have it in your inbox within minutes.
Okay, right.
That's practical. And then we can jump on a Zoom call tomorrow or Sunday and discuss. I'll just let the buyer's agent know that no offers will be entertained until probably Sunday, when we either accept or counter or reject your offer. And I'm going to be crystal clear with the buyer's agent that the offer will not be presented immediately. It's going to be acknowledged, it's going to be seen, but there is not going to be any moving to either acceptance, counter, or rejection. Does that make sense? Okay, cool. All right, any questions regarding 9.6? All right, so now let's talk about the Business and Professional Code 10-176. Okay, now we talked about the National Association of Realtors. I also talked about the California Association of Realtors. I also talked about the multiple listing service. Now we're going into the Business and Professional Code under Rules and Regulations 10-176 of the Department of Real Estate. Damn, the DRE. So yeah. All right, the commissioner, meaning the commissioner of the real estate department, right? The real estate department says this, that the commissioner may, upon his or her own motion, and shall upon verifying complaint in any written of any person, investigate the actions of any person engaged in the business or acting in the capacity of a real estate licensee within the state of California, and he or she may temporarily suspend or permanently revoke a real estate license at any time where the licensee, while a real estate licensee in performance or attempting to perform any of the acts within the scope of this chapter, has been guilty of any of the following. Okay, so I want you to understand, and it's not common practice to know all the codes. I mean, you can purchase the real estate law book, and it's probably this thick. You can go to the DRE's website. You can also download it on a PDF file, or you can purchase the hard copy of it, which is probably 25 bucks. It's a lot of jargon in there that is more geared to attorneys, right? Because that's the legality of their profession, is to find anything that they can pick up on you, any what we call dirt, right? Well, Business and Professional Code 10-176 is part of that stipulation, saying A, B, or C says the following: making any substantial misrepresentation, false information, right? Lying, misleading, taking shortcuts, making any false promises of a character likely to influence, persuade, or induce the clients, the principals. C talks about the continuance of fragrant courses of representation or making a false promise to real estate agents or salesperson, right? We never guarantee, and giving false promises and giving misrepresentations of anything can cause you A, B, or C under 10-176. Folks, I am not the Department of Real Estate, but the Department of Real Estate is an investigation, and I've had investigators coming into the office. I've had investigators inquire about a complaint, and they're being very efficient now. They have beefed up their Department of Real Estate's investigation unit, and now they're really being proactive to really see that all agents are, doing the right thing. So you never want to be in the scope or on the eye of the Department of Real Estate. Remember what I said earlier. DRE is not our friends, right? And they're really not, okay, just like the Department of Real Estate, the Department of Motor and Vehicles, right? Yes, they issue you a driver's license, a commercial's license, motorcycle endorsements and all the endorsements. But as fast as they can give you one, they can also remove it if you get a DUI or, even, I've seen situations where the county or even the state, on child support, they'll suspend your license. So they have that authority. Well, it's no difference with the real estate license. This is why you want to make sure. And the reason I'm bringing this up, because it kind of all falls together with everything that we just talked about, the codes of ethics that are involving, because you are held to a higher standard. And your job is to protect your client's best interests and always do the right thing. So, please make sure that you're following all the rules and regulations regarding that, because you do not want to be yourself entangled in the mess of the DRE. I'm just saying, okay? I have no control over you. I can only educate you and guide you and consult you. At the end, once you leave, that's on you, okay? But there's pros and cons. Yes, you have the umbrella of Keller Williams. Yes, you have the E&O insurance that protects you, but we're not going to protect you, or the ER is not going to protect you if you're doing something fraudulent, something unethical, right? Because you should have known. Shame on you, okay? And if you don't know, it's best to ask. I'm here to help. I'm here to guide. I'm here to consult and give you the right advice, because my license is also in jeopardy. You get in trouble, I might get in trouble because I oversee, right? And I'm speaking for brokers throughout California. Okay, so don't put me in that position either. Okay. Any other conduct, whether of the same or different characters than specified in this section, which constitute fraud or dishonest dealing. And I highlighted these two and obvious that, because it's very, very important to understand your position, right? The commissioner may suspend or revoke the license of a real estate licensee, delay the renewal of a real estate license, or deny the issuance of a license to any applicant who has done any of the following: demonstrated negligence or incompetence, and in performance or acting for which he or she is required to hold a real estate license, right? Common sense, folks. Common sense. Okay. Hope that makes sense. I hope this grasp, do the right thing always, and you'll survive real estate. Okay. Engage in any other conduct, whether of the same or different character than specified in this section, that constitute fraud. Okay. Fraud is very, very serious with the DRE. Anything that has to do with fraud, they're immediately on it. Okay. And yeah, it's very hard to challenge. By that time, you may have to get representation, attorneys involved, and you may have two attorneys, one suing you and then one's trying to save your real estate license. So it can be very, 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 very expensive. Okay. So always do the right thing. Any questions? All right, common law fiduciary duties. This is a very important one. Fiduciary duties. You probably remember this. I remember in real estate school. I took real estate classes in college. I didn't do the real estate school. I went the long way for some reason. I just didn't know the shortcut way in getting my certifications. But anyways, I remember my instructor, who was an attorney, and he was teaching real estate law. He always would use fiduciary duties, responsibility, your responsibility to your clients. Well, the law imposes on a real estate agent the same obligation of undivided service and loyalty that imposes on a trustee in favor of the beneficiary. This relationship not only imposes upon him the duty of acting in the highest good faith towards the principal, meaning the buyers, the sellers, the investors, or the developers. Good faith towards its principal, but precludes the agents from the obtaining any advantage over the principal in any transaction had by what's that word? Virtue of agency. Yeah. And there was a Supreme Court back in 1968, Batson's versus Stradlow. Okay. And you can look it up and read about this particular case study. I promise you we're almost done, folks. I hope, I know I'm a little over my time. I think we have just a couple more presentations. All right, now rule 9.1, showings and negotiations, appointments for showing and negotiating with the seller for the purchase of a listed property filed with the service shall be conducted through the listing broker, except under the following circumstances: A, or B, after reasonable efforts, no less than 1 day after the cooperating broker cannot contact the listing broker or his representative. However, the list broker at his, at his option may procure such direct negotiations by the cooperating broker by giving notice to all participants through the multiple listing service. In the event all showing and negotiations will be conducted solely by the seller, the listing broker shall clearly set forth such facts and the listing information published by the service. Okay, so meaning that showings and negotiations are part of our component of our position, right? But if you don't get any answer or anything from the listing agent, say I'm the listing agent, right? And you've been texting me, emailing me, calling me, and I'm not responding, but my listing that I have on Torrance, right, is active, and active means please present offers, but I haven't heard from the listing agent. What it says is that after reasonable efforts, okay, that I have the cooperating approach to go directly to the seller, okay, and bypass the listing agent and go or knock the seller and say, hey, I've been trying for the last couple of days reaching out to your listing, your agent with negative results. I have a buyer that's ready, willing, and able to buy and wants to submit an offer. We didn't want to waste, time of the essence on this, and we wanted to present. So I had no choice but to present the offer to you directly. Okay, so that's what the showings and negotiations and representations invoked in delegating and determined. So. All right, sample letters of demand to offer to present. So under the California ZIP forms, there's a section under forms. Other than your real estate contracts, there's another sections which stipulate forms, letters, and all that good stuff. The California Association of Realtors. There's a lot of awesome, powerful letters that you can use. And one is a demand demand that the offer be presented, meaning that we're asking you, listing agent, that we'd like to present the offer to your seller. Demand the offer to be presented. You go into the form section, and then that's where it would show, all of these awesome letters that you can use. And these were drafted by attorneys by the California Association of Realtors.
That's a letter demand or asking that you personally be able to present the offer?
That's correct. Demand that the offer be presented. Yeah. So here's the sample of the letter. Agent's broker address, date to the listing agent, property address, demand that the offer be present. Dear Mr. and Mrs. Seller, right? I represent Mr. and Mrs. Buyer, right? Who has made a written offer to purchase the above described property. To neither nor the buyer have received a response to the written offer we checked here. Buyer previously submitted offer to the purchase is attached. I submitted the buyer offer to purchase the property to you on so-and-so date in the following manner. And then here was personally delivered, email, fax, or other. Proof of delivery. And then you can also, after submission of buyer's offer, I made concerning efforts to insert seller's respond by contacting or attempting to contact you as documented below, but ultimately no availability on that. And here you can put date, time, phone, email, or other. Remember, everything is paper trail. Everything is evidence that if you need to challenge this, you want to have everything documented. Paper trail is what we always say, because it's not what I say, but what I have in writing that will protect you, but also will push for you to win your argument or your case as well. Make sense? Then 5 says your failure to present the buyer's offer to the seller. This is going to the real estate listing agent, which I have reasonable belief to be true, as you have not communicated any response from the seller to me, may have serious consequences. You may be in violation of the law, the DRE license rules, the multiple listing MLS rules, and ethical rules More specifically, a failure to present the offer to the seller may have rise a lawsuit brought against you and your broker by the seller or the buyer for legal claims such as, but not limited to, breach of fiduciary duties and wrongful interference with the prospecting economic relationship. Furthermore, any dishonest dealing, negligence, incompetence, or sequential misrepresentations is grounds for revocation or suspension of your real estate license. So it goes in deep on this, okay? And then it goes on to the second page of that as well. And that's again part of what we have as the resources for our position. And then we have additional resources, quick guide, offer presentation. You just go to the California Association of Realtors, which most of the stuff that I gather, put together and present, you also as a member of the California Association have the right to get that as well. And that concludes our presentation. Any questions? I know that was a lot of information and sometimes a little overwhelming, but I hope you at least get a little bit of just what you need, the meats and potatoes of it. And always, always reach out to me with any questions or concerns. I'm here to help navigate and ultimately give you a perspective and how, you should navigate these offer presentations. There's ways to do it and there's wrong ways to do it as well. So, just keep that in mind. You can always reach out to me via email, Simon Casares at KW, or you can even text me as well. So, all right. Any other questions before we wrap it up? All right. Well, cool. I appreciate you all. Thank you very much. Be on the lookout. I think we already have the classes for October. So we have the classes already ready to rock and roll in October. So our next class is next week. I think we're talking about amendments and addendums as well. So it's going to be a great topic. That'll be next Tuesday at 2 p.m. Okay. Appreciate you all. Thank you very much. Have a fantastic afternoon. And remember, stay out of trouble. Bye for now.